Welcome, everyone. This is the second MBE session of the Ibis Prep November Essentials course. We just played Jeopardy and we reviewed towards the contracts. And I think for the second straight week, Gabby was the winner, but that is because she's been putting in work since October, so hard work pays off. But we definitely have some new contenders. But as always, we're going to start off with Sam, who's going to spend some time teaching us about study strategies, motivation, and all the things that come about with the mindfulness and the preparation necessary to pass this test. So Sam, go ahead and take things away.
Hey guys, how's everybody doing this evening? Thank you for coming to the second week. You know, this is one of my favorite tests. Insert sarcasm. The MBE, I've taken it many times. And like Andrew said, I do remember, like, I was like, okay, forget this. I'm going to just do Florida and I'm going to take the test half and half. And then I talked to somebody and they were like, listen, you're going to still at least do a little MBE on the side. A little MBE turns into, I wouldn't call it an obsession, but I think the best way to divulge in the MBE is to fall in love with it. Not in a like obsessed with it way, but in a way where it's like, oh yeah, I'm competing with you and I'm going to get all these questions right. Okay, so we're back. I wanted to double check with everybody again. How are they feeling? I know some of us are taking Florida and MBE. So to begin, I want to say, try to do 1 day MBE and then 1 day Florida. It makes it a little bit more manageable, especially with the different type of subjects. Now, if you're only studying for MBE, then lucky you get to do MBE every day. But at the same time, I would say do a lot of questions 1 day, and if you're feeling tired, do some review the next day, but still use real questions to review. Still use their explanations, your notes, fix your little outlines, but use real questions when you're going to review, because MBE is very important that you just not practice, but you have to understand why you got the questions right and why you got the questions wrong. Okay, so I did this for Florida, so I'm doing it again. This was my score breakdown when I passed the MBE. They say that you should try to get at least 30% on each subject. As you can see, I was a little short in crim law and a little short in civil procedure at 54, because that's usually like one of my weakest subjects. And as you can see, torts, I love torts. Mine was 94.9, and that really helped me compensate for the 2 sections that I weren't doing so good at. So like I said, let your strengths bring you the victory. That's why I encourage mixed practice, because when you mix practice, you're going to practice subjects that you're good at as well, and you're going to get better and better and better at those subjects. Whereas if you just focus on subjects that your brain, it just doesn't click, you're going to be missing out on points, because it's about the points you can get and not trying to get every point, if that makes sense. You're just trying to get majority of the points. You got to know some certain issues. You just practice into test day, and then by test day, whatever it is, you take it with a grain of salt and you pray about it. But make sure you're practicing your strengths, because they can help you go over the threshold. When you are practicing, you want to see that your practice scores are at least at 75%. 80 is honestly way better, obviously, but you know, you're going to expect it to do a little worse than you did in practice. So if you're doing 80% in practice, you know, you're probably going to do about 75% on the exam. So that's why you should try to do as high percentage as you can get, because you know that's going to heighten your chances of passing. I'm very big on practice tests. I know a lot of people who don't really do things like do practice tests, or they like Adaptabar, but I like practice tests. Adaptabar does have practice tests. They have 4. So even though it seems like it's only 4, you could do 4 2 times. It's really going to help you, because you're going to see a lot of questions that you're going to get stumped on, and then you're going to review it. And then the second time you take it, you're going to be like, oh my gosh, I remember this question. And you're going to really, really, really learn from it. Just like when we got the intervening and superseding incorrect. And now we know it, because we can't, oh Lord. Now we know it because we can't forget it, because remember we messed up. So once you mess up, it gives you the motivation to learn it. And there's a reason why you messed up. There's something that didn't click. And once you realize what didn't click, the explanation is going to help you realize what does click and what makes sense. What's the rule and why didn't you figure out with the facts that connects to the rule? What's the rule? What's the facts? You have to connect all three of them to get both of them to get the right answer. I like to say, if you don't do practice tests, if you're just going to do adaptable one by one, or your 25 questions a day, then at least try to take 2 practice tests a month. You don't have to do the full 200, but at least do 100 question sets. I honestly didn't have time to do 100 question sets in a 3-hour slot, but I did try to work in 3-hour slots. So I would do 50 questions or 40 questions, how many my brain could take, and then I would review for like the next hour, just so I know that I'm not overwhelming myself. But the key is to learn. You have to learn from each and every question that you're doing. So to tackle an MBE question, the first thing you need to do is practice. You can't tackle any questions if you're not practicing. There's nothing to it but to do it. This is not like essays and other things. With MBE, it's strictly doing the questions. It's strictly practicing. Fall in love with MBE, like I said, and complete your daily and monthly goals. Like I said, try to do 25 questions a day and 2 practice tests a month, minimum. Okay. And like I said, try to work in 3-hour slots, because the MBE is 3 hours. It is a mental beast, mainly because you have to sit there for 3 hours and answer these questions and try to figure out what they're saying. And then you're on one subject on one question, then the next question is another subject. It's a lot of balancing in your head, and you have to do it for a long period of time. So you have to try to build that stamina now. I like to practice perfect just to get as close to perfect as on game day. So another thing that you need to do when you're practicing MBE questions, like I said, is check your answers efficiently. Adaptable has amazing explanations. Like they'll have an explanation that's like long, and it's giving you about 10, 12 rules in one explanation, because 3 options are wrong, and you have to, and there's going to be a rule connected to those 3 options that are wrong on top of the option that's right and the rule that's right. So grab all your answers, everything from your explanation, and check your answers efficiently so you're getting all the points that you can as you go. Guessing is good in emergencies. When you get on test day, if you see a question and you have a blank, yes, you're going to guess. But when you are practicing, try not to do the guessing game. I used to practice like, okay, I'm here with the question. I don't know the answer. What would I do on test day to make sure that I got this question right, or have the highest chances of getting the question right? And I would practice that so I know like what I guess my guessing strategies actually worked. Was it, any, meeny, miny, mo, I did little silly things like that. And when I was guessing, but practice makes perfect. So even if you are practicing a routine for what you're going to do, once you get into see a question that you don't know the answer to, what is my method? Because sometimes you'll get to a question that you don't know and you'll immediately panic. But if you practice not panicking and just practice a little system that works for you, then it will benefit you. I like to say, when you're reviewing your questions, don't move on until you know why the answer was wrong or why the answer was right. A lot of times you'll be like, oh, never mind, I'll come back to it. You don't have that much time to come back to things. So try to do things the first time. Obviously, sometimes your brain can't take it, but as your standard, try to say, okay, I'm not going to move on until I know why I got this question wrong. Last but not least, you need to identify your weak issues. MBE is very repetitive, but it's only when you get to a certain amount of questions that you're going to see the repetition. So in the meantime, if you know, okay, separation of powers, I'm not good at separation of powers, then you cross it out and you put on your little list of issues that you need to go back to. I'm not good with formation. Like when I did contract questions, that would be the main one that would trip me out. And it's just because they were so tricky on if there was an offer and if there was consideration, that once the facts come in, the rules, it's like, it's so hard to apply the rules sometimes because you get so ahead of yourself. And I used to know when every time a formation question will come up, I will know this is my weak areas are, because you have to go back to study them and also know where, don't put too much attention on. If you know that formation is killing you, then definitely try to do a video or reach out to one of us, Andrew. Even in the chat that we have a chat, and people always ask questions like, hey, or share questions. Sometimes I would send questions to my friends like, why is this answer B? Can you explain it to me? And then we will help each other. So if you want to send me questions, please send me questions. But identify your weak issues so you can try to combat them as well as you can. So the biggest question that people always ask when it comes to MBE is, how many questions should I do every bar administration? I think everyone is different, and I think you should do as many questions as you can, but I think 2,000 and up is reasonable. You don't want to sell yourself short, and everybody's learning curve is different. So if you know that MBE is a difficult test for you, and you know that you've been not scoring as well as you want to, you're in the 40s, you're in the low 50s, you need to keep practicing. Once you get to the 75s and the 80s, I wouldn't be so concentrated on quantity. But if you're in the 40s and the 50s, you probably haven't taken enough questions and haven't reviewed enough explanations. Okay, but we have 110 days left to the bar exam. And so if you at least do 25 questions every day for 90 days, so that means I gave you 20 days off. For 90 days, you would at least do 2,250 questions. Okay, you can always add to that, but I think that's a good and doable, being that we're in November, goal. You guys can do 2,000 questions. It's no biggie, okay? I want to thank Suzanne because she shared this quote with me. Our greatest weakness lies in giving up. The most certain way to succeed is always to try just one more time. So I just wanted to leave that as a sweet reminder that I see a lot of retakers right now. They're already feeling it. They're already feeling sad. They're like, oh, I don't want to do it. But be proud of yourself that you are trying one more time. And then when you succeed, it's going to be so much better knowing that you didn't give up and you kept trying and trying again. Again, I gave my meditation of the week on Monday, and I linked it here as well. It's the same meditation as for confidence. You know, MBE is a big, big, big confidence thing. You have to have confidence when you're reading the questions. You have to have confidence when you're picking your answer. So I think that would be a great start for the great finish to the week. Get your confidence up and know that you got this. The MBE don't have nothing on you, okay? You're smart. You're intelligent. Again, I am your fairy bar mother, Samantha Collier. This is my contact information if you need anything. I'm so happy to see that a lot of people showed up in class today, because it's just like, as you'll see that as time goes by, you know, people will get weary and they'll get tired. And I know the assignments are a little overwhelming in the beginning, but you guys will definitely get a hang of everything. If you need anything, please reach out. Even if it's to vent, it's okay. Send your text, dish it out on the end. You're good to go afterwards, okay? But again, thank you guys for joining us, and I'm so happy you guys are here. Are you guys doing your 25 questions a day or no? Have y'all been doing your questions?
Don't want to sign.
I'm a little late to the game, but I'm here now, so.
Okay,
Yeah.
I'm telling you.
I just
okay,
need
so
an
let's forgive.
thing. I don't
We're
think
gonna
I
forget anything before today. We have 90 days for sure. You could do 2,250 questions. Even if you do a practice test, you could do 25 questions at a time. And again, give yourself time to review your answers, because that's going to be the most important part of getting your score up. And if you don't see that every time you're doing questions, your score's not raising, then try a different method. Excuse me. But you should be seeing your score increase by week. Even if it's like 2%, 3%, you'll see the difference in when you're reviewing your questions and when you're actually retaining the information.
Amazing.
Excuse me, I have a cold.
Oh no, sure.
I have a cold, so excuse me for my hoarseness.
No, I didn't hear any hoarseness at all. What we're gonna do is take 1 or 2 questions from the audience. I'm gonna ask the first question, and then we'll take 1 or 2 more. Here's my question that I need to know. Most of my students complain. I don't like to use that word. Most of my students pontificate that they got too much going on. They're sick. Let's say you're sick today. Sickness, family, excuses. I don't want to use that word, so let's take that out. But all these different things. And then I look at you, someone who really had a lot on her plate. So on a day-to-day basis, what would you say that, how do you get 25 questions done? If that's the goal, how did you get 25 questions done on a daily basis with all the things that you had on your plate?
So the MBE is done on paper. I'm a big advocate for studying how the exam is. So I used to love to carry MBE questions with me all the time, anywhere I was. I used to have them with me. And I used to, wake up, pray, do my meditation, and I used to have a goal for the day, my bar goal. I never put a time on it. Usually on the weekends, I can say, okay, from this time to this time, I'm going to study. Or during the week, I couldn't put a time on it. I just would start my day knowing that I'm going to do 25 MBE questions, make sure it's printed out. Like I would print it out the day before, whatever I was doing for tomorrow, have it with me. And any moment I had, I would literally do some questions. Because, I scroll on my phone all the time. So I used to think like, okay, if I could study instead of scroll on my phone, I could get some points. And so it's like every time I would be bored, I would just be like, okay, I'm just gonna do some questions. I'm not gonna go on Instagram. I'm not gonna start a conversation with my friend. I'm gonna do some questions. And even if I did them slow, where it's like no pressure, no, no graded, no putting a time limit on my question, they say you have to do it in like a minute and almost 2 minutes. I would just engage with the question and enjoy it. I know this sounds so ridiculous, but I swear I would, because it's just, okay, I want to get the question right. And it just made me feel good to get the question right. And even if I did get the question wrong, it made me feel good to figure out what I did. So I would just have them with me and do them whenever I could. And if I know that it was like about 10 o'clock and I didn't do my questions, like I said, give me 5 at least, 5, 10. I wouldn't do 25 every day. I would do what I can. And sometimes it would be like 5, sometimes it would be 10. But I would start my day knowing this is what I need to do every day and make sure that it was printed out and ready for me so I wouldn't have any problems through the day. So I would prepare the day before to have all my materials ready for tomorrow. Okay, so what am I studying tomorrow? What subject am I doing? What essay am I doing? And that way it helped me stay on track and I wouldn't like be in a frantic or be able to make any excuses because everything was already printed out. My plan was already done. So all I had to do was just do it. Pretty much.
Wait, you printed questions like and then had it hand, or was it on your phone, like on the adaptive bar?
No, I printed them. I'm a paper person.
From adaptive bar?
So if you make your adaptive bar questions like a quiz, then you can print them out at the end as a report. And so like I would do silly things like cover it up with a little piece of paper so I didn't see the answer, and then do the question, then pull up my sheet of paper and be like, oh, I knew that was the answer. Or if I didn't, but I like to have it on paper. But I did have like other practice tests like from Studicata, and those were easy printable. But adaptive bar, yeah, the only way you can print off adaptive bar is if you make a quiz, do a quiz, and then after you can print out your report.
Okay.
Samantha, can I add something?
Yeah, sure.
One of the things that I do, just because I'm here by myself all the time, is when you make a list of things to do, like, if you want to do 10 questions or 25 questions or whatever, I keep that up for my next day as my list of accomplishments from the day before. So this way I don't feel burdened. I feel like, oh, I've done 25 yesterday. You know what? Maybe if I add just maybe one more today, or if I only did 10, maybe I can add 5 more today. But I see my accomplishments.
That's awesome.
And it might just be a Post-it note, but it is what it is.
It is. That's perfect. Maria, did you have a question?
Yes, I want to ask you because I still have the Barbie printed thing from, the last bar prep. And I also want to ask you because I was trying the Thinkific or whatever bar questions that you have. And I saw some difference between the real bar questions. The adaptive bar, of course, are the most likely, and also that what we find in different websites. So were you trying all of them, or you were just focused on adaptive bar?
Yeah, I did adaptive bar. I did Studicata. I did Emmanuel's. I did any practice test I could find, because I don't know, I just was obsessed with practice tests because it made me feel like I was doing the real thing. And especially when taking the exam so many times, like I remember how I felt, and I remember like the type of questions that I was taking on game day. So I took as many questions. Even with Kaplan, they had a what's that book called? And it's like with incredibly hard MBE questions in there. I forgot what it's
Is that
called.
the red
It's
book?
like, huh? It's a red book, yeah.
Yeah, Kaplan red
Um,
book, workbook.
no, it's a red workbook.
Yeah.
I did that one too, not the manuals. It's a Kaplan book. But it's notorious for being hard. And it's like even if whenever you find questions other places, it's just good to at least reinforce rules because you still need to know the rule to answer the question. So even though it wasn't all adaptable, I love to use different questions just to see, if on every network I could still, regurgitate the rule and know how to answer the questions. So it helped me just, be more versatile because with the MBE, it's like, it's reading comp, PMBR, yes, that one. PMBR. Those questions are hard as heck. So I did some of those too, just so I could be versatile because I was terrified of the MBE. So I tried everything.
Nice. What I'll say is, and I've always said this, it's not the material that makes people pass or fail the test. We are creating our own Q banks right now that have really difficult questions. All of the other companies out there have solid questions, and what Sam said is right. You should be able to pass them all on different platforms, because it's not how well do you know the questions that you've seen over and over, it's how well do you know the material. At the same time, I'm a big believer in repetition, right? Repetition and learning are highly correlated. So people tell me, Andrew, I don't like doing the questions on this platform because I memorized them all. I'm like, okay, so then if we do 25 questions right now, you should get all of them right. And then they don't. And I'm like, so you haven't memorized them all. So before you say you memorize them all and start, hating on the platform, memorize them all. I guarantee you, if you just do that, you'll pass the test because you're saying you've memorized them all, but you haven't. And if you did memorize them all, then you would be familiar with enough patterns on the test that you would pass the test. So I'm going to go ahead and straight up say this. If you're a robot and all you did was memorize the 1,600 disclosed MBE questions that all of these different Q banks that you're discussing all have, you would pass the test, but you actually have to memorize them. What we're doing is creating new questions to try and, account for that idea that you've seen all the questions over and over again. The other thing that Sam said that I thought was really great was she enjoyed it. She got 5 kids, she got a full-time job, she's doing too much, but she said she looked forward to doing questions. She liked her little moments of peace where she was doing 10 practice questions. You must do that. In life, whatever you are doing, you have to learn to love it and enjoy doing it. People like Andrew, I see your schedule. You have 8 students a day, and then you teach a course, and you wake up at 5 a.m. to go network. This must suck. I mean, not really. I like what I do. I like my job. I like helping people, and I have a positive attitude during it all. And then my days go by too fast, man. I'm getting gray hairs, right? So slow down, enjoy what you're doing, really learn the material, and have pride that you're learning very, very difficult material. Am I freezing at all? Anyone? Okay. Oh, no, I'm not freezing. Oh, if I ever do freeze, someone let me know because I don't want to be frozen.
Yeah, you just lag like a little bit, like from time to time.
I am lagging. Okay, yeah. I feel that. I'm gonna go downstairs in a less lagging environment and start the lecture. But yeah, exactly. What I would say is that you have to enjoy this test, and it's not something easy to do, but it's something that we definitely can do, and you just have to make the most of it. Any environment you're in. Like my internet starts lagging a little bit. Okay, I'll change the environment and I'll start teaching here. Same thing. Sam's studying and her baby starts screaming. Okay, she'll cradle the baby and do some questions. You really have to make the most of what you're doing and recognize that no one in this room is facing a journey more difficult than anyone else. I really do believe that. All right, perfect transition into the material, right? I'm going to start off by sharing my screen. And does anyone have any preferences of doing real property or common law first? I'm happy
They both
to
suck.
teach either. What'd you say?
I said both of these
They both
subjects
suck.
suck for me.
Yeah. I think that's the perfect transition from my speech about loving.
I mean, I love them both.
Yeah, there we go. You love them both. All right. And which one do you love more, would you say?
I would say
Common law or real property?
I love
If
property more, yeah.
Yeah, you love property more. I love property too. You know why? Property is where all the money is. People think that practicing law is fun and you make a lot of money. If that were the case, right, I'd probably be practicing law instead of doing this. It's not the most lucrative and fun career unless you are, oh, sorry, unless you do real property, right? Because real property is where all the money is. If you're a real property attorney, you could be very happy, very successful. So I like real property. It's where the money is, and I like making money, and I want to own property. So real property is fun. I do love it, and we're gonna learn. Let me know if I'm lagging. I don't know what else I could do. All right, see, this is my album cover. Ill Gotten Gains, that's my rapper name. Restitution, that was my first album. It went platinum in the bar world. And some facts about me. No one really cares about this stuff. Mindfulness, Sam already covered. Tell yourself you're gonna do this, you're gonna pass this test. All right, let's look at property. So this is kind of a blurry chart, but we could see ownership of property is 20%, rights in property is 20%, real estate contracts is 20%, mortgages and security devices is 20%, and titles is 20%. What does that mean? It's all over the place, right? Real property questions are literally all over the place, very, very difficult, long, convoluted questions, parties, conveyances, hard to keep facts straight. Just dig deep and know the material. You know, I've had students do very, very well in real property MBE, studying exclusively from our material. So this process does work. All right, fee simple states. So we have fee simples. Just understand what that means. Like a fee simple is ownership in a land, right? So you could have fee simple absolute, which means it's your land and you keep it forever. That's ideal. You could also have a defeasible fee, fee simple determinable, fee simple subject to condition subsequent, and fee simple subject to executory interest. So fee simple determinable, we're looking for durational language. Fee simple subject to condition subsequent, we're looking for subsequent language that's conditional, like, but if A gets married, but if A moves to a different state, but if A becomes an attorney, then to B. The difference between fee simple determinable is fee simple determinable is an automatic right of reversion, meaning that it's automatic so long as it is not used to sell liquor. The minute they stop using it to sell liquor, it reverts back to the original party, right? We're conditioned subsequent, but if he gets married, then they have the right of reentry. And then subject to executory interest in real property, think of a third party. So there could either be springing or shifting. Springing will spring from the grantor to the third party, whereas shifting will shift from the grantee to a third party. So springing would be my property goes to B if B gets married. That would spring from A to B upon the event. Shifting would be my property goes to A, but if A gets married, then to B. So shift to B from A. Again, this is a condensed course. We're not going to go into the weeds of things. I'm just going to tell people the basics. All right. Life estates. So as opposed to a fee simple, a life estate means you have it for the duration of your life. You cannot commit waste, actual, permissive, ameliorative. Actual waste, banging on the door, punching a hole in the wall. Permissive, letting things rot. Ameliorative means improving the property, but still actionable. A life estate tenant must pay property taxes, insurance, ordinary maintenance, and mortgage interest on the property. The remainder man is responsible for the principal of the mortgage. They do like to test this. So the life estate tenant has to keep up with the expenses of the property, the taxes, the insurance, the maintenance, and the mortgage interest, right? But the remainder man has to pay the principal of the mortgage. Why does the remainder man pay the principal of the mortgage and the life estate tenant pays the interest? Because the remainder man is the one who actually inherits and owns the property. So he's got to actually pay for it. But the life estate tenant is the one who pays to live there and has to pay the living expenses. So that would be the interest on the property. That's a very tough concept for people to grasp. But November, remember November, Andrew did say something about life estate tenants versus remainder men, and remainder men actually being the ones who inherit the property. So it is more justified for them to pay the principal of the mortgage. Okay, joint tenancies. We have tenancies in common, JTROS, and tenancies by the entirety. Tenancies in common are A and B have a property. If B dies, then B's heirs will take. JTROS, A and B have a property. If B dies, A survives B, right? It has to have the 4 unities: time, title, interest, and possession. Tenancy by entirety is JTROS plus marriage, right? Just so you know what a strongman is, that's a third party that they would convey the property to and convey it back to the married parties to satisfy that element of time of the JTROS. What's this important point? Concurrent owners have a right to use and possess the whole. If 3 tenants in common and 1 rents the house, the other 2 have the right to live in the house. If they are denied, this right is considered ouster. That is an important point, right? So you might not see that, but if you are tenants in common and you rent it out to someone, and then the other 2 parties are like, yo, you're renting it to this dude, and he's like, yeah, sorry, I didn't tell you, the other 2 tenants have the right to come live there with that dude. And if not, that's considered an ouster. Rule against perpetuities. Let me skip this. No, I'm just kidding. I'll do my best. All right. So no interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at the time the interest was created. I can only explain 2 good examples. Oh, perfect. Sexy grandma. I coined that term. They used to call it fertile octogenarian. Me, the progressive professor, I called it sexy grandma. This is how it applies. And I'll just explain this quickly. If it goes all the way over your head, don't worry. Rule against perpetuities may be 1 or 2 questions on the test at most. All right, sexy grandma. This is the concept where grandma is 80 years old and she has a kid who's 32, right? And she conveys a land to any of my kids who reach the age of 30. And she's single and unmarried, and then she's 89 and she's in a wheelchair, right? But she's sexy. That would still, it doesn't matter that she's sexy, I'm just whatever. That violates the rule against perpetuities. Why? Because isn't it possible that next year the kid dies, the 32-year-old kid dies, okay? See you later. Then sexy grandma scooting around the retirement center finds a nice young chap and, you know, they have a baby. Well, isn't it true that that baby may or may not reach the age of 30? And after 21 years, we're still not going to know if it's vested or not? That's why I would violate the rule against perpetuities. I know that's a crazy example. That's what they teach in the law schools. At least now you guys have this image of your mind of sexy grandma rolling around. But that's rule against perpetuities in 1 minute or less. So, all right. Freehold estates. Landlord-tenant, right? Landlord-tenant duties are pretty obvious. You've all been landlords. You've all been tenants. I'm sorry, not all been landlords. You've all been tenants. Hopefully you all be landlords. Actually, probably hopefully not. Why? Because landlords have tenants and tenants violate their duties, right? Tenancy for years is for a fixed period. Periodic tenancy is like month to month, week to week. Tenancy at will, it can be terminated at any time. And tenancy at sufferance is a holdover tenant. Assignment versus sublease. So assignment is for the remainder of the lease term. A sublease is for an interim period, like very different. Because if A and B, A is the landlord, B is the tenant. A rents it to B for a year, and then B lives there for 6 months and then says, hey, C, come live in this place for the remainder. Well, that would be an assignment, right? And that would actually put C in privity with A and B and all the parties because they've been assigned, so they could be held liable. Now, if it's just a sublease, 12-month lease, and B subleases to C for the interim 3 months, the summer months, because he knows the battery, because he knows the summer months are hot in Florida, so he subleases for the summer months. Well, C is not in privity with A, so A could not collect from C. So no, those are the main differences between the assignment and the sublease, is that the assignment is for the remainder, where the sublease is just for the interim. Okay, land sale contracts. Let's talk about these. All sales for land must be in writing in order to conform with the statute of frauds. Under the doctrine of equitable conversion, during the period of escrow, The buyer is the equitable owner and bears the risk of loss unless explicitly contracted otherwise. So remember how land sales work. We have a contract and we have a deed. The contract is signed, we're going to close in a month. That period in between the contract signing and the deed closing is called escrow. And during that period, if the property burns on fire, then the buyer will bear the burden of that. That's what equitable conversion doctrine means, that they are the equitable owner, even if they're not the legal owner. All land sale contracts come with the implied guarantee of marketable title, no encumbrances on the land. So what constitutes an encumbrance? Like a mortgage, a lien on the property, threat of litigation or litigation, an easement on the property, basically anything that's not ideal. Because think about it, if you bought a piece of property and then you found out that there's a freaking easement on it and Tommy could just walk over at any time, you'd be pissed. Title is a legal possession of land, while deed is a legal document that grants title, right? Because you can have title without a deed. How? Adverse possession. Deed by estoppel occurs when someone without authority transfers title, but then later receives authority. The first deed transfer will be validated by the later authority transfer title. Deed by estoppel happens all the time on the test. Johnny conveys to Tommy, right? But Johnny did not have authority to convey to Tommy. But then later, Johnny receives authority, he inherits the land, or he's gifted the land, and then tries to deny his earlier conveyance to Tommy. He'll be stopped from doing that. That's what deed by estoppel means. When someone conveys land to someone before they had authority, when they later receive that authority, and they've already conveyed the land when they didn't have authority, they're stopped from denying that earlier conveyance, and now the party that they conveyed it to earlier will in fact have title. Action to quiet title is appropriate when there are conflicting claims on a property. So that's when, hey, it's my land, it's my land, it's my land. Well, let's figure it out. Action to quiet title. There's a duty in residential property to disclose latent defects, and always a duty not to misrepresent. So a duty to disclose latent defects actually comes from Florida, Johnson v. Davis, where you have a duty to disclose known defects or defects that you should have known about. That's residential property, not commercial. Let me just see if anyone's joined the room, because I know sometimes people get kicked out. Anyone have any questions about anything so far? I know it's not a super interactive lecture, but it's just because it's a condensed course and I'm going through the material. Remember, it's just to remind people of, oh yeah, I remember. Late December. Mortgages. Man, mortgages. No, I'm just kidding. Hooray, mortgages. So a mortgage is a security interest in land. It's a debt that is secured by a property. In the event that a mortgagor fails to make payments to the mortgagee can institute a foreclosure action. Makes sense, right? A mortgage is when one party lends money to another party and they secure that loan with land. Equitable right of redemption versus statutory right of redemption. So equitable right of redemption, think of I'm dating myself here, but Happy Gilmore, the reason that Adam Sandler was playing golf in that movie was because he was trying to buy his grandma's house back. And even though it had already been up for foreclosure, they did have the equitable right of redemption to buy it back before the sale. And then even after the sale, in some states, they may have had a statutory right of redemption to buy it back. That's what that right of redemption means. It's like you have the right to buy back your property either before or after the sale. Subject to versus expressly assume. I put these in bold because they're heavily tested, and if you know these well, you'll do well. Subject to versus expressly assume. If someone takes subject to a mortgage, that means the original mortgage holder is still primarily and personally responsible for the mortgage, and the second person is secondarily liable. If someone expressly assumes a mortgage, they become primarily and personally responsible for the mortgage, but the original mortgage holder is still secondarily liable as a surety for the mortgage. I'm just realizing I may be freezing. Am I freezing? A little bit? Am I lagging?
No.
Not that bad? Okay. If I am, please someone interrupt me because I don't want to like be lagging. And I know my internet in my house is not the best for whatever reason. Okay, so subject to versus expressly assume. If I was a mortgagor. And remember, the mortgagor is the person who takes out the mortgage. The mortgagee is the bank. So I'm the mortgagor, right? And then I'm going to transfer my mortgage to B. Let's call him Brian, my brother's name. A, Andrew, B, Brian. That works out well. So Andrew's going to transfer to Brian, right? The mortgage. Now, would Brian rather expressly assume that mortgage or take subject to that mortgage? The answer is Brian would rather take subject to. Because if Brian expressly assumed, that means Brian is literally stepping into the shoes of the original mortgagor and saying, I'm personally liable for this. This is my responsibility. If he only took subject to, it means that he is the surety, secondarily liable, and I am still primarily liable. So it's kind of that situation, like taking subject to a mortgage means you're becoming secondarily liable. Expressly assuming a mortgage means you're becoming personally liable. So easements a non-possessory right to cross another parcel of land. Express versus implied. Express written, implied could be like oral or by prescription necessity. Easement appurtenant. I can't sing that song, It Takes Two. I think I'll get a copyright infringement. No, I'm just messing with you. But It Takes Two, right? Like there's a dominant parcel of land and a servient parcel of land, as opposed to easement and gross, which is just personal. It's tied to a person, not the land. So think of like a utility pole as easement and gross. Easement appurtenant, think of like a regular easement. Easement by necessity, you know, when you need to access a public road. Easement by prescription, it's kind of like adverse possession, open, continuous, exclusive, adverse, notorious, hostile, but it's not actually exclusive because multiple people can have the same easement. Overuse of an easement may lead to liability for a surcharge. Affirmative easement is, you know, your right of access. You're allowed to cross over something. Whereas a negative easement is a right to restrict. You know, like land or air. You know, you're restricting someone's from impeding your use. And the remedy for overuse or violation is injunction, right? You get an injunction or a surcharge, as I said. Adverse possession, I mean, without going through this too hostilely, open, continuous, exclusive, adverse, notorious, hostile, it's got to be for the statutory period. So look out for these questions. They could be tough. They can involve tacking, meaning like you could tack on the time period, or it could be like two people adversely possessed together. It's like some tough scenarios. Adverse possession is not as simple as it sounds. Covenants and equitable servitudes, the main difference between them is that a covenant is remedied by legal relief, money, and equitable servitude is remedied by injunctive relief or equitable remedy. But these are promises tied to land. Like in my townhouses in the Grove, we all have to have blue doors. If I painted my door yellow, they'd be like, Andrew, you need to paint it back blue. That is a equitable servitude. Now, it's interesting to know if an equitable servitude can run with the land, right? Or real covenant can run with the land. Just know that real covenants require more to run with the land. They require vertical and horizontal privity. Well, it's relaxed, but they require privity compared to equitable servitudes. They're required to be in writing compared to equitable servitudes. They both need intent and the touch and concern of the land and notice. So you have to have notice, intent, and touch and concern of the land. But the elements of privity are more relaxed, and the element of being in writing is more relaxed when it comes to equitable servitude as a covenant. A covenant is written and it can run with the land if there's horizontal, well, if there's privity. Vertical privity means subsequent buyers and sellers. Horizontal privity means the original buyer and seller. All right, perfect. That's all there really, that's all. That was some essential information about real property. And this PowerPoint has a lot of these cram guide points that I took right from, questions and the answers, and I just teased out the applicable rule of law. So cram guides, details, devils in the details, detail pointers, and then this cute puppy are the way they have successful experience on the MBE when it comes to real property. And I are part of the Google Classroom, you'll have access to all these things. And just to show everyone the Google Classroom, so everyone who has Google can click these 9 squares, and somewhere on your 9 squares, there's this green Google Classroom. For me, it's at the bottom. For some people, it's in the middle. But it's green Google Classroom. And might take a second to load.
I think you're like breaking up in terms of like talking.
Yeah, it's just because it's loading right now. But it's a good breaking point for me to. Any jokes for the class? Okay, well, unfortunately, my Google Classroom is not loading right now while I'm on Zoom. But in that Google Classroom, there's access to all the materials, assignments, recordings, and everything. So I think it's for better that you can't see the Google Classroom because I might have got distracted. But just make sure that you're following up with all the Google assignments, the Google Classroom assignments for 1 second, for real property, because that was a fast lecture and I know I didn't go over everything, but hopefully if you go over the Google Classroom assignments, you go over the Thinkific is already loaded up. There's the concepts quiz on Thinkific, and there's the 25 question, MBE like quiz. The concept quiz is a lot of questions. I think it's like 100 something. So I would start early on them. Okay, let's take a turn, if you will, to constitutional law. Now, does anyone have any feelings about the Constitution? Do you like the Constitution, dislike the Constitution? Pro-Constitution, anti-Constitution?
Well, looking what's
Best thing
happening.
ever created.
Go ahead, I'm sorry.
Well, go ahead. What were you saying about the Constitution? How does the Constitution of America compare to the Constitution of France? This is
I was
specifically.
saying it's the best thing. It really gives the opportunity for us to have rights and the government to more or less control society and the craziness out there. Thank God, I don't know if you're seeing what's going on in the Middle East and in Europe and all that. They don't have a beautiful constitution like in the US, therefore they're struggling. So I'm all for it.
Nice. And Brittany, I'm texting you the codes for Google Classroom right now. But does anyone have any other thoughts about Google Classroom? About the Constitution?
The Constitution now, for me, makes it hard to study for, because you can't look at what's happening in the real world and look at what's written, because they don't seem to correlate anymore in a lot of cases.
All right. That's a fair assessment. So someone says they like the Constitution and someone says they don't like MBE Constitution law questions because they don't think they correlate with what's going on in the world. Fair points. And Brittany, I tried to send you that code, but let's just tap in after class because I can't really do that in the middle of class while I'm trying to lecture, but that code will give you access to the class, to the Google Classroom. All right, moving along. The Constitution.
Andrew, at the bottom of all your assignments that we got on day 1 that was sent by Jesse, it's at the very beginning, that code.
Yeah, I know. I can't type. If you can share that code in the Google chat for Brittany, that would be amazing. All right. So let's talk about con law. The Constitution. I want to give you my 2 cents on the Constitution real quick. Good start. I think very good perspective. That's what I made in the class. Compared to what's going on in the rest of the world, it's really amazing document. That's a good perspective for me to hear because I am kind of a hater of the Constitution. I think we could do better, but we could certainly do worse. So that's a very good perspective. Why do I think we could do better? Because the Constitution was written 300 years ago. It was written by old white people who had interests in mind that didn't align with our interests today. And then over 300 years, it's been interpreted loosely to align with motivated individuals whose motivations have changed over time. And, I guess when you say the test questions are hard because they don't align with the Constitution in the real world, I would say the Constitution in the real world doesn't align with anything in the universe. So it's a very tough subject in general. But one of my favorite sayings, it is what it is. We just got to study the law and learn it to the best of our ability. Memorization is the key to all of this. If you can memorize the first 16 amendments to the Constitution, that's a good start. If you can memorize all the different authorities of the legislative branch, executive branch, and the judicial branch, that's a good start. Well, not good start, that's a good second part too. If you could just go over the details and memorize things, that's how con law will be best applied. And certainly the scrutiny levels, strict scrutiny, intermediate scrutiny, rational basis, knowing when to apply those levels of scrutiny and their exact definitions, it all comes down to precision. I'll be the first to admit that, I've taken this test more times than I mean, it's my job. I like taking it, but every time I've taken the test, con law has never been my highest section. It's always like some questions that I believe are a little bit subjective. The lemon law, does it really apply today? Did it really ever apply? They say one nation under God since the 1950s. That doesn't seem like separation of church and state to me. You swear on a Bible when you are, admitted to court or whatever. Like, it's very loose, very, very loose. But I'm not here to talk about looseness and tightness. I'm here to teach the law. So how are we doing? Look, that's me. Can you guys see my screen? Am I sharing screen? Oh yeah, I am. That's me, my grandfather, and my father. We're all graduates of University of Miami School of Law. My grandfather actually loved the Constitution. So for what it's worth, people are allowed to think what they're allowed to think. And he was smarter than me, so he's probably right. All right, so mindfulness is very important. We talked about this study strategy. Sam said 2,000 questions, 25 questions a day. I would say try for 4,000 questions, 50 questions a day. But 25 is a good start, great start. 10 is a great start. 5 is an okay start. 0 questions a day is not good. What about the Constitution? It's going to be 50% individual rights. It's going to be 16.7% the nature of judicial review. It's going to be 16.7% separation of powers, and 16.7% the relation of nation and states in a federal system. So what does this really mean? And sorry, my whining dog is forcing me to move back upstairs. But what does this really mean? It means that individual rights are tested heavily. The rights of an individual under the Constitution. And remember, for there to be constitutional implications, there has to be state action. You have to have standing. These are some original concepts we're going to look into. Oh, what do you know? Standing. A person must have a concrete stake in the outcome of a case at all stages of litigations, including appeal. Injury in fact, causation, redressability. Ripeness bars consideration of things before they've developed. Mootness bars their consideration after they've been resolved. Ripeness, it's too early. Mootness, it's too late. Certainly look out for that. Adequate and independent state grounds. So adequate and independent state grounds mean that the Supreme Court is not going to hear cases that the states can handle on their own, right? Like if there's independent basis for the state to resolve a claim, then why would the Supreme Court hear it? Look for that answer. That's a good answer on the test. Adequate and independent state grounds. I'm really sorry if I'm lagging just a bit. I hope everyone can bear with me. Levels of scrutiny, triple important, super important. Strict scrutiny, fundamental rights. What are fundamental rights? Like camper, contraception, marriage, procreation, education, the right to raise your children, the right to vote, the right to travel, access to courts, First Amendment, freedom of speech, freedom of religion, freedom of the press, 14th Amendment, 5th Amendment, due process rights. Like all these things are going to be subject to strict scrutiny. The government must show that the action is necessary to achieve a compelling interest and that is narrowly tailored and is the least restrictive means available. Intermediate scrutiny. Well, before that, we got to talk about the suspect classes too. Race, alienage, national origin, and those are the main suspect classes. Race, alienage, and national origin. And then the fundamental rights. Those are all things that are going to be subject to strict scrutiny. Intermediate scrutiny is going to be for things like gender or illegitimacy. The government must show that the action is necessary to achieve an important interest and that's not substantially burdensome. Look out on the test though, it has to be targeting gender or targeting legitimacy of a child, right? It can't be that it affects one gender disproportionately, right? The classic question is public school has a rule where no one can have shorts above their knees and all the women complain and it affects them way disproportionately. That is not going to be targeting women because it just affects women. It's not targeting women. Therefore, it'll be rational basis. And rational basis is when the plaintiff must show that the action is not rationally related to a legitimate government interest. So rational basis is wealth, age, pretty much everything else when it comes to levels of scrutiny. Anyone have any questions so far about just disability, standing, adequate and defend state grounds, or levels of scrutiny? All right. I talked about fundamental rights. These are all things that are going to be subject to strict scrutiny. Try to memorize these. Camper, I put abortion in parentheses because that's what I was saying earlier about the Constitution. Abortion is not a fundamental right anymore, according to the Supreme Court. Was it 5 years ago? Yes. Was it a year ago, year and a half ago? Yes. So it's very hard to keep up with the Constitution. Maybe it would be smart to just start over with a clean slate. But that's just my very dumb opinion. Contraception, marriage, procreation, education, right to raise a family. Laws directed at race, alienage, and national origin, suspect classes, right to travel, right to vote, access to courts, First Amendment, freedom of speech, freedom of religion, due process rights on the 5th and 14th. I literally said every one of those things. All right, First Amendment, freedom of speech. Unprotected speech includes fighting words, obscenity, inciting imminent lawless activity, defamation, false or misleading commercial speech, right? Everything else is protected under the First Amendment. There's a difference between content-based and content-neutral. Content-based is what you're saying. That's strict scrutiny. Content-neutral could be subject to time, place, and manner restrictions. Like, there's no one's allowed to speak on this sidewalk because it's too loud and there are old ladies studying inside, right? And it's public property. That's okay. But if they said no one of this religion can speak here, that would definitely be content-based. Time, place, and manner. A good example is like Ybor City in Florida, Tampa. There are gentlemen's clubs, strip clubs that are only in Ybor City because they're not allowed in other parts of the city. Why? Because it's a valid time, place, and manner restriction to restrict that speech to a certain part of the city. Again, the Constitution is not black and white by any means, but that's kind of an understanding of strict scrutiny for content-based and time, place, and manner restrictions for content-neutral. Public forum needs to be content-neutral versus limited non-public forums need to be viewpoint-neutral. Content-neutral would be like no campaigning about or no speaking. Content-neutral would be like the war in the Middle East. That's content. So a public forum, it can't be about that. Limited public forums are viewpoint neutral, meaning like it can't be on this side of the war or that side of the war. It's a viewpoint. Like same thing with abortion. Abortion would be content. Whether abortion is good or bad would be viewpoint. So limited and non-public forums just need to be viewpoint neutral, whereas public forums need to be content neutral. This is talking about restrictions on speech. So to wind things back, November Essentials course, First Amendment protects the freedom of speech. Freedom of speech is the protection from the state impeding upon your speech, but there are certain types of unprotected speech. When I said obscenity, remember obscenity is speech that appeals solely to the prurient interest of mankind. It has no artistic value. That's why, nudity or pornography could be protected because it has artistic value. Freedom of religion, we have free establishment and free exercise. Remember that a religion is a sincerely held belief. Due process, so procedural due process, just think of notice and hearing, right? They cannot deprive you of notice and hearing if you're like a federal employee or a state employee or some federal due process rights. Substantive due process is deprivation of all rights, whereas equal protection is deprivation of a specific group's rights. I give the example of a mask, right? When we had to wear a mask during COVID, one could argue that that was substantive due process violation. You were, making me do something that I didn't want to do, but you're making everyone do it. So that we could all argue substantive due process. Not that I didn't want to wear a mask. I'm pro everyone doing whatever they want at all times and leaving me alone. Okay, anyway, equal protection, and I'm not pro that either. I'm pro nothing. Let's go with that. I'm pro nothing. Okay, equal protection would be like if they said all men have to wear masks. They would be targeting the men, right? So equal protection is a particular group, and substantive due process is all people are being, the rights are being impacted. Commerce Clause, very common answer on the test, and the Dormant Commerce Clause. Under the Commerce Clause, Congress can regulate the channels and instrumentalities and economic activities that in aggregate have a substantial effect on interstate commerce. So we know the classic examples of the Morrison and the Lopez cases. This is growing marijuana in the closet versus guns in a school zone. Now, can the federal government regulate whether or not you can grow marijuana in your closet, Tommy? Yes, they can. Why? Because Tommy could sell to Johnny. Let's say Cheech could sell to Chong, right? Cheech could grow the marijuana in his closet and sell it to Chong, and that would be commerce. So the concept of interstate commerce is that it's one step away. Like there's a classic question on the MBE. I say classic question, I don't even know what I mean by that. There's questions on the MBE where there's a question I know of where they're growing this grass all over and the grass gets you high, but there's no commercial value because the grass grows everywhere. Can Congress regulate that? The answer is no, because there's no economic value to it. Marijuana, I was about to make a joke, has a high economic value. What about the gun in the school zone? Can they regulate that? The answer was no, because there's no economic value. We're talking about selling guns. We're talking about guns in school zones. That would actually probably be a violation of the commandeering clause, where under the 10th Amendment, anti-commandeering, the federal government cannot force the state to enact legislation. So if they force the state to enact legislation about gun laws, that would be commandeering clause violation. If they made a law that said, hey, we're not going to allow states to have good road funding unless they change their drinking age to 21. Well, that's conditioning. They're not forcing them to change their drinking age to 21. They're just making them have potholes if they don't do it. Anyway, I'm kind of getting off topic a little bit, one of my specialties, but Commerce Clause, we're talking about regulating the channels, instrumentalities, and economic activities of interstate commerce, and Congress can do that. That's how Congress gets away with regulating a lot of stuff. Let's just make that very clear. When in doubt on the MBE, that's a strong answer choice. It's way better than like necessary and proper. That's a weak answer choice. Commerce Clause is pretty tasty. And then Dormant Commerce Clause. Dormant Commerce Clause, also known as the negative implications of the Commerce Clause, is the understanding that states cannot enact legislation that will discriminate or unduly burden interstate commerce. So we think of the classic case where the state of Georgia has a law that says, cars have to have tires of certain size. Well, that would unduly burden truck drivers coming from Florida to South Carolina. Every time they went to Georgia, they had to switch their tires. That's unduly burdensome. So look out for that for the Dormant Commerce Clause. Privileges and immunities. Note it applies to individuals, not corporations. They like to say that MBE is like a minimum competency test. I'm like, no, it's not. The MBE is a maximum trick question test. And one of the trick questions they love to do is, privileges and immunities. You know that they can't discriminate against out-of-staters, but they're not discriminating against the individual. They're discriminating against a corporation. So the Dormant Commerce Clause, so the Privileges and Immunities Clause does not apply. Dormant Commerce Clause would apply. Privileges and immunities would not apply to corporations. It only applies to individuals. This is the correct answer when a state is denying rights to individuals of other states, right? Like charging more for a commercial fishing license to people in Georgia than Florida would violate it. Charging more for residential, like a Disney pass, would not, because that's like that's not denying them the rights. But a commercial fishing license charging different rates for Georgia and Florida residents would be a violation of privileges and immunities. Think of this when they're denying rights to individuals of other states. Taxing and spending, this is going to get its power from the 16th Amendment. And just as a matter of course, everyone out there should know the 16 amendments, right? First Amendment, freedom of speech, freedom of religion, freedom of press, all that mumbo jumbo. Not mumbo jumbo, all that really important stuff, especially at this time. Second Amendment is the right to bear arms, also very important if you ask some people. Third Amendment, I don't think anyone thinks this one's important, is you don't have to quarter a soldier during wartime, but don't worry about that. Worry about the First Amendment. Fourth Amendment you should also know about. Fourth Amendment is unreasonable search and seizures. We're not down with that. You think of the space as mnemonic because we're not going to allow an unreasonable search and seizure without a warrant unless there's an exception to the warrant. Exceptions to warrants would be search into arrest, plain view, automobile exception, consent, exigent circumstances, or stop and frisk. Fourth Amendment stuff. Fifth Amendment, there's 5 things on the Fifth Amendment we should know. Due process is granted to us via the federal government on the Fifth Amendment. Fifth Amendment, I would love to show this clip. I just don't have enough time. But Dave Chappelle saying, I plead the Fifth. That's talking about, if anyone knows that's from Chappelle's show, that's saying that I plead the Fifth. I have a right against self-incrimination. So due process under the Fifth Amendment, your right against self-incrimination under the Fifth Amendment, right against double jeopardy under the Fifth Amendment. No person shall be held for life or limb twice under the Fifth Amendment. The takings clause is the Fifth Amendment, where they cannot take your property without just compensation. And then your Miranda rights, your right to counsel before adversarial proceedings have begun. Sixth Amendment is your right to counsel after adversarial proceedings have begun, your right to confrontation under confrontation clause, and your right to a speedy trial. Seventh Amendment is your right to a trial by jury, federal, when there's monetary relief. Eighth Amendment is cruel and unusual punishment. You can skip the Ninth Amendment. 10th Amendment, I talked about this earlier, state sovereignty, where states can enact legislation that's not preempted by the federal government. Police power, think about the anti-commandeering clause. 11th Amendment is sovereign immunity, where you can't sue a state. Like Tommy just can't sue a state unless the state consents, or Florida versus Georgia, that would be okay. 12th Amendment you could skip. 13th Amendment, freed slaves, and also it is what prevents discrimination based on race in private settings. 14th Amendment is due process to the states, equal protection. 15th Amendment granted voting rights to people cannot be denied color or race. And then 16th Amendment is taxing and spending, right? They have plenary power to tax and spend. And for all the ladies out there, of course, the 19th Amendment was voting rights for women. Anyway, I know I just rattled that off quickly, but my point being is that I want everyone to know that the 16th Amendment's like I hate that saying the back of your hand because I don't think you guys know the back of your hand that well. I want you to know the first 16 amendments, like Taylor Swift's next album. All right, taxing and spending, they have plenary power, tax and spend. On the bar question, look for the answer to be like, it's okay. The federal government can do this because they have broad authority to tax and spend. Legislative power is important. So this is Congress, taxing and spending, war-related powers, Commerce Clause, investigatory powers, property power. There's no federal police power except on federal lands, DC, military bases, etc. Bankruptcy power, postal power, power over citizenship, admiralty power, the power to coin money and fix weights and measures. Taxing and spending, Commerce Clause, power to declare war. Those are some big ones. Executive powers, El Presidente. I don't know if anyone watched the presidential debates last night or whatever. I did not, thankfully. I'm just too busy, thankfully, to be caught up in presidential debates. All right, so executive powers, to veto power over congressional acts, executive powers to take care that laws of the U.S. are faithfully executed, treaty power, State of the Union power to commander-in-chief, appointment power, also removal power, pardon power, and power to call a special session of Congress. So executive powers, the president, it's pretty unbridled in terms of removal, appointment, and pardon. You know, they can pretty much do what they want, but they do have to act in coordination with Congress in a lot of ways. The president has treaty power, so know that the hierarchy is that the Constitution will prevail, and then treatise is on par with federal law, and then a executive order will be below that. Executive agreement will be below that. Judicial power, so the Supreme Court and the federal judicial power. The Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. That's a key sentence right there. Unfortunately, they test things that are from like intricate senses of the Constitution. That's one that they test. That Congress may ordain and establish, so they might edit, delete, modify, whatever, appellate jurisdiction. But they can't touch the Supreme Court's original jurisdiction. So look out for that question. They can, modify and eliminate appellate jurisdiction, but not Supreme Court original jurisdiction. And the original jurisdiction involves cases such as between the states, actions involving various public officials. So we're talking about ambassadors, consulates. What are they called? Mongos? Not Mongos. Something. But people that are involved with diplomacy, diplomats, let's call it. Not Mongols. I always say something funny every couple minutes. So the Supreme Court's original jurisdiction involves cases applying to disputes between states, actions involving various public officials, disputes between the United States and a state, and proceedings by a state against citizens or aliens of another state. And then Supreme Court has discretion to hear cases via writ of certiorari. That means appeal, someone writes, say, hey, Supreme Court, this is a very important issue. You want to hear it? And they're like, yeah, you know what? Let's hear it just so we can ban abortion. That's what they did. They didn't just come out and ban abortion. They listened to a case that enabled them to not ban abortion, but you know what I'm talking about. Enable them to make decisions related to abortions. Okay, so now here are additional considerations. We're at the finish line. Takings clause under the Fifth Amendment, private property cannot be taken without just compensation. Look for that. Commandeering clause I talked about. The federal government cannot compel a state to enact legislation. It can only induce them. So it can, it can't say you must enact this law, but it can say if you don't enact this law, then we're going to take away your funding. Federalism, state laws are preempted by federal laws. And also remember, the states can't tax federal entities. The federal government can come inside the state and do what they want, and the state cannot tax them. There's, they could potentially tax like a agent who's doing his own business. That's different, but just on a general level, know that rule. Sovereign immunity, you can't sue a state for money damages unless the state consents, the federal government consents, but you can sue state officers for injunctive relief. Elements of the Constitution, I call this slide Elements of the Constitution because I went to University of Miami and one of my teachers there, William Wyden, we did a whole course called Elements, and I swear the entire semester, sorry. My dogs are it's supposed to be in the class. The entire semester, all we talked about were these three things: bill of attainder, ex post facto law, and impairment of contracts. And I always found it empowering. That's something that my teacher talked about an entire semester. I could talk about in 1 minute. And I think that's kind of the problem with law school. All right, so elements of the Constitution. Bill of attainder. This just means we can't throw people in jail without a trial. See how fast that was. Ex post facto law. This means that we can't retroactively punish people for behavior that was not punishable at the time. And then impairment of contracts means the government cannot impair private or public contracts. So, curfew laws would most likely impair contracts because, especially here in Miami, I live across the street from Flanagan's. They're open till 5 a.m., that would impair that. All right, I think that's the last slide. After this, I just have some cram guide pointers. And like I said, you can see when I do these MBE lectures that there's so many points at the end that are cram guide pointers because at the end of the day, I'm just trying to teach the fundamentals, and then you have to go through the practice questions. If you like the torts and contracts questions we assigned, you're gonna love the property and con law ones. We refined them, they're amazing, and there's way more content ones, or what are they called? I forget what it's called. Basics, essentials ones where you can really understand them. So there's like 100 of them for real property and like maybe 50 of them for con law. So that'll really help. So I just have one question for the class. Does anyone know who was the second president of the United States?
John Adams.
Yes, John Adams. And we like John Adams. Well, I don't know if we like him or not, but we like him more than the other ones, maybe, because him and his son, John Quincy Adams, were the only two of the first 10 presidents who did not own slaves. So, you know, it was still a choice back then, regardless of what they say. All right. I really hope everyone enjoyed the lectures today. Sam, as always, you did amazing. I know we went over time, but today I had the time. Usually I have to stop sharp at 8:30, so that's why today I was like, let's, you know, have some fun. I know these are tough sections. I encourage everyone to, you know, be a part of the Google Classroom and do the assignments, follow along, and we'll just keep it moving. It's just an essentials course, so just know you're out working the competition right now. Most people haven't even started studying yet, and you all have listened to me talk about a lot of really tough concepts. So I really appreciate everyone for joining me tonight.